his last CLE of 2019 for Christmas, so thanks for being here. We're going to do a couple of housekeeping things first before we begin the program. So the first thing I want to do is introduce the president-elect of WICLA, Laura Rubeck, who was elected a week ago today, and will be installed at the installation dinner at the London House on January 18th. It's going to be a great event, so please try and attend the installation dinner on January 18th. So first of all, congratulations, Laura. And what Laura and I are going to do, first of all, is conduct the raffle for the early registrants to WICLA. So you remember a month or so ago, a couple of months ago, you received a notice from WICLA that said if you register early for 2020, your name is going to get entered into a raffle for a drawing for an iPad Pro, which is the first prize, and the second prize is a $250 Let Us Entertain You gift certificate. So we're going to do the drawing for that, for the early registrants right now. So anybody want to register early before? Only kidding. So we're going to do the second prize first. This is going to be the Let Us Entertain You gift card for $250. Okay. So let's do this way. It says here. So,
first name is Brian Reader Batterman.
Brian here. Representative Gasky, will you bring it to him? Thank you.
We don't have it right now. John already left it in his office.
Well, this is for the.
He's bringing it now.
This is the gift card. So okay. So now we're going to do the. We'll make sure you get this. Okay, thank you. And this is for the first prize, which is the iPad Pro.
Mark Schlechter, Southern Law Group.
Mark Schlechter, holy cow. So many years and iPad Pro. So Mark isn't here, but we'll make sure that we contact him. So there you go. And now Laura has a couple of announcements about the MCLE program. We have to get into more strict compliance with the MCLE rules about how we do things around here. We've been kind of a little bit too loosey-goosey over the last few years, and it's time for us to get into compliance. So Laura's going to tell you how we're doing this.
Good afternoon, everyone. Actually, the MCLE rules just changed over the summer. They went into effect multiple days that they are alleged for certain things. But the biggest one is that you can't issue blank CLE certificates anymore. They have to be personalized. Obviously, we're not going to write out 100 different personalized CLE certificates, so that's going to require us to start online registration. It's not starting today, but it's over the next 6 to 8 weeks, you'll start getting announcements about that process. We will never turn away people at the door. We will have iPads that we set up that we can accept registration and a walk-in. It won't take that long, but we would encourage people to register first. You can do it on your smartphone. You can do it however you want, much like what we do for the golf outing and the medical seminar. So it shouldn't be too laborious, but you will need to have an actual email certificate. So today we do have the blank ones sitting up. We are going to upload the ARDC numbers of everyone that attended to the MCLE board to confirm the attendance, and then I'm going to generate some certificates that will be emailed to you guys in the next couple of weeks. That's what is the valid certificate. So if the MCLE board ever audits you or audits us, if you have these certificates that you handwrote, they're not going to count that. So you need to get the email ones. So if we don't have somebody's email, we'll try to track it down this time, but going forward with the registration process, it'll be connected to your ARDC number, exported into a spreadsheet, and then we send it off to the MCLE board. So it'll be easy. We'll have developing a new system so you can track your WICLA CLE. It's going to be really nice. It'll be a little bit easier in some respects, and those who are anti-online registration, I understand it's one more thing to do. But unfortunately, we want to be in compliance with the rules, so that's going to be starting up hopefully by February. Yes? Well, we're changing our platform completely, so that's going to be much easier. It will be all on the same platform. So you watch the video, you complete the certificate on the same page, it gets sent out. We have to check the portal, if you will, every month. Those, whoever watched, see if people watch the video, those ARDC numbers get exported into a spreadsheet, and then every month we upload it to the MCLE board, and the certificate is generated. No, we haven't ironed out all the details yet. We're still figuring out what's what. But the plan and the hope is that we can keep them online and available now for, technically we can keep them up for a year, but in terms of, you have to report to people that watched it then within a year. So I'm thinking maybe 10 months, we'll have them up and you guys can watch them during that time. So that'll, I think, be a lot easier for everyone. And once you take that certificate, I believe, you guys don't quote me on this, I'm still trying to figure it out, that the certificate will be immediately generated. For the online viewing and live viewing, but sometimes Google does that too. You go and email you the certificate after the fact. That'll be how it is for all the brown bags and other things. We're going to try to make it as easy as possible, so it shouldn't be too much of an upset to how we do things. But again, the added benefit is that all the one of the added benefits, all the WICLA CLVs will be in one place that you can access like Google and IXP. All right. Thank you, everyone. If you have any questions, I have to head back to mediation, but Katie, Dylan, and Dave are very helpful, and you guys all should have my number too, so call me. Thank you, everyone.
And thank you, Representative Ugaski, for being here. Everybody knows Dan Ugaski. He survived his first session in the General Assembly this past year. He's around to live to tell about it, so thank you for being here. Some of you may know that Representative Ugaski is a former president of WICLA and still a proud member of WICLA, so thanks for being here. So today what we're going to try to do is the year-end wrap-up. One thing before I forget. Are any of the newly appointed arbitrators here? Arbitrator Amarillo, will you stand and be recognized, please? So and Arbitrator McLaughlin is here too. Thank you for being here, arbitrators. So what we're going to do today is kind of a year-end wrap-up, but as I was putting this program together, I decided that maybe it's better to talk about what we're going to be facing in 2020 rather than what we did in 2019. So the first thing I want to talk about are these new arbitrator assignments. So we're going to start at the end of the program, so if you'll all turn to the last page of the handout, you're going to see that the Commission published yesterday or the day before the new arbitrator assignments for 2020. So you're going to see that Arbitrator Amarillo has taken over the role that was previously designated TBA, which I want to say was the Arbitrator Bocanegra. So that is now Arbitrator Amarillo. Arbitrator Reyna will take the call previously designated by Arbitrator Salini, and you're going to see that Arbitrator Salini is being moved out into one of the zones. Arbitrator Christopher Harris, who is one of our newly appointed arbitrators, will take the call previously designated as TBA 4, and again I want to say that was Arbitrator Cronin's call. Arbitrator McLaughlin is going to take the call previously designated to Arbitrator Robert Harris. So the question that we have is, are we going to have to start calling it Arbitrator Harris 1 and Arbitrator Harris 2, or how we're going to do that, but I suppose we'll figure that part of it out. The other Chicago assignments remain the same. So now regarding the zones, Zone 1 is Arbitrator Cantrell is going to take the place of Arbitrator B. Arbitrator Cantrell is a newly appointed arbitrator. Arbitrator Gallagher and Novak are going to stay in Zone 1. Zone 1 is Mount Vernon, Tarrant, and Collinsville, so that will now be Cantrell, Gallagher, and Novak. Zone 2, Arbitrator Dennis O'Brien, another newly appointed arbitrator, is going to take the call previously designated as TBA 5. I want to say that that's the Arbitrator Hemingway call. Arbitrator Lee will take the call that was designated as Arbitrator Cantrell, and Arbitrator Polio will remain in Zone 2. So our Zone 2 is Springfield, Quincy, and Urbana, and that's now going to be O'Brien, Lee, and Polio. Zone 3, Arbitrator Adam Heinrichs, who is a newly appointed arbitrator, will take the call previously designated to Arbitrator Seal. Arbitrators Rose Sullivan and Granada will continue to serve in Zone 3. Zone 3 is Rock Island. Somebody help me here.
Bloomington and Peoria.
Rock Island, Bloomington, and Peoria, and that's now going to be Heinrichs, Rose Sullivan, and Granada. Zone 4 is going to be Arbitrator Saline, replacing Arbitrator Dollison, who I'm sure you all know by now is retiring. At the end of the year, we will miss Arbitrator Dollison. Arbitrator Doherty will take the place of the previously designated TBA2, and I've lost track at this point who that was, Flores. Okay? And Arbitrator Hegarty will take the call previously designated to Arbitrator Abachi. You can see where he's been moved in a second here. So Zone 4 is New Lenox, Ottawa, and Kankakee, and that will now be Salini, Doherty, and Hector. Zone 5, Arbitrator Abachi is going to be moved into the slot previously held by Arbitrator Hegarty. Arbitrator Seal will take Arbitrator Doherty's call, and Arbitrator Paul will remain in Zone 5. Zone 5 is Rockford, Woodstock, and Waukegan, and that will now be Herbachi, Seal, and Wall. Zone 6, Arbitrator Robert Harris will take the call previously designated as Ori. As you all may know, Arbitrator Ori is also retiring, so thank you, Arbitrator Ori, for your service. Arbitrator Soto and Friedman will remain in Zone 6. Zone 6 is Wheaton, Geneva, and Elgin/Wheaton 2. So that will now be Harris, Soto, and Friedman. Any questions? Because I'm not doing that over. All right, yes.
Dave, I was out in Peoria yesterday, and Tina Pittman retired. She's the one that runs the Peoria office. Do you know offhand, because they didn't know yesterday, do you know offhand if there's a replacement for Tina that's going to run the Peoria office?
So the question is, Tina, who ran the Peoria office, is retiring also. Is there anybody who's going to take over running the Peoria office? I don't know the answer to that question. Does anybody here know the answer to the question if there's going to be somebody taking over the Peoria office? I'm getting some shakes of the head, no. It doesn't seem like that's been decided quite yet. All right, so let's go back to the program. So one of the things that we always try to do with the last program of the year is set you up for 2020. So once again, in 2020, WICLA is going to conduct these lunchtime programs that begin at noon here in this auditorium. You're going to have to do this new registration program. Walk-ups are not going to be turned away. You can register at the door. You're not going to walk out of here with a certificate anymore like you've done in the past, because apparently that was not necessarily in strict compliance with the rules, but no harm, no foul. We'll let bygones be bygones, I suppose. So all the programs will take place here in the auditorium at noon, and will end at approximately 1 o'clock. You may have heard that the state of Illinois is making arrangements to sell the building. When that happens, I suppose many years from now, we're going to have to find a new auditorium, so we may not be here forever, although I guess nothing lasts forever. The other things on this schedule that I do want to point out are the special programs. So once again this year on Lincoln's birthday, which is Wednesday, February 12th, when the commission is closed and the building is shut down, we are nonetheless going to be here in this room for the professional responsibility boot camp, where you can get 3 hours of professional responsibility Credit, the professional responsibility credit will include the special kind of hours, 1 hour each, the diversity inclusion hours, and the mental health and substance abuse hour, and then an hour of professional responsibility. So you have to do 6 hours of professional responsibility in a 2-year reporting period. So if you attend the WICMA program on Lincoln's birthday 2 years in a row, you knock off your professional responsibility credit, and you also meet the requirements for those special kinds of hours, the diversity hours and the mental health hours. So we're doing that again. And then we're going to have 3 special medical seminars. Traditionally, we've done the fall one. We're going to continue with the fall one. We're going to coordinate that with the Workers' Compensation Commission judicial training. So that's going to be sometime in September, probably a Wednesday in September. And we're also, again, this year going to do an April program for a medical seminar, and that's, again, in coordination with the springtime commission training, and that's going to be on a Wednesday in April, yet to be determined. This year, we're going to continue to do the summertime program, which we started last year, so there's going to be a special 3-hour medical seminar program on Monday, June 8th. So mark that in your calendars as a special program. So as you can see here, we've got a pretty full MCLE schedule already, docketed for next year. If we need to add programs, we can always do so. But this is at the very least the program that we intend to present next year. Any questions, comments? Anybody want to say anything? Yes, sir.
I just have a question on the February 12th show. Will that be video as well?
Yes. So we will be taping all of these programs, and we will be presenting them online or on video, or however this new system, this platform is going to work. So yes, the professional responsibility program will be taped just like the regular programs and just like the medical seminars. Anything else? All right, good. So, again, looking forward to 2020, you may all know that NCCI, which is the National Commission on Compensation Insurance, sets the insurance rates for Illinois for the following year. They do that in September, so in September of 2019, NCCI sets the advisory rates for 2020, and you can see from this chart, which we've tried to keep over the years and publish to our members, again on January 1st, 2020, NCCI has recommended an advisory rate reduction for insurance rates in Illinois, and the reduction beginning on January 1, 2020 is going to be another 5.1% reduction. The cumulative reduction in the rates since 2011 now exceeds 56%. And if you look at that column regarding the loss cost has actually gone down by 50% during that same period of time. What are rates? I think everybody kind of understands what rates are. So rates are the factor that is applied to payroll to determine what the premium might be. So for example, the rate for a farm worker, which I looked up this morning, might be $7 for $100 of payroll, right? So for every agricultural employer that has $100 in payroll, NCCI recommends that the rate be $7 for every $100 of payroll. So you can figure out what your premium is as an employer by taking your rate and multiplying it by your payroll, right? There are some additional add-on factors that result in what the actual premium is, but the basic simplistic formula is that it's your rate times your payroll, and that should equal your premium. So everything else being equal, your payroll being equal, your modification experience, how many claims you've had in the previous year, everything else being equal, if you're the average employer in the state of Illinois, your premium should go down by about 5.1%. beginning on January 1, 2020. You know, if you have a higher payroll, of course, the premium is going to go up because it's rate times payroll that equals premium. So why is that important? It's important because you'll recall a year or so ago, we talked about a new law that was passed in Illinois. And that new law said that employers were entitled to a premium increase notice from their insurance companies when the premium exceeded the NCCI rate recommendation, right? Because the idea being is that everything else being equal, if NCCI recommends a 5% less rate, as an employer, you should be paying a 5% less premium. The question is, what happens when you're not paying a 5% less premium, right? What happens when the notice that you receive from the insurance company says that your premium went up 10%? Well, now you're entitled to a notice as an employer from your insurance company that says your premium is going up by more than 5% over the NCCI recommended rate, and here's why, insured employer, that your premium is going up in that way, right? You had too many claims last year, whatever it might be, but employers are entitled to this notice. So doing a little bit of math here, if there's any increase in an employer's premium for next year, that employer is entitled to notice, right? Because if the variance is 5% and the reduction is -5, right? Any increase at all is more than 5% over the recommended rate, right? So any employer who is getting a premium increase from their insurance company should be receiving this kind of notice. So for those of you on the respondent side, when you are hearing complaints from employers about why did my premium go up, they should have received a notice from their insurer about why the premium went up. Okay, everybody understand that? Okay, great. Any questions? Okay, good. All right. One of the things that's going to happen on January 1, 2020 is that the minimum wage in Illinois goes up, right? Why do we care about the minimum wage in Illinois? Well, we care about the minimum wage in Illinois because the workers' compensation minimum rates are tied in to the Illinois minimum wage, right? So the minimum TTD rate and the minimum PTD rate are 2/3 of 40 hours at the Illinois minimum wage or the federal minimum wage, whichever is higher. And it's already higher, but beginning January 1, 2020, the minimum wage in Illinois is even going to be higher than what it is right now. So we talked about this law last year. It was actually the first public act that Governor Pritzker signed. It increases the minimum wage to $9.25 per hour beginning on January 1, 2020. There's another increase in the middle of next year on July 1st, 2020, and it goes up to $10 an hour at that time. So I did a little bit of math, and I hope I've done the math correctly here, but as far as I have done the math, the minimum TTE and PPE rate beginning on January 1, 2020, and I suppose that's for accidents that happen after January 1, 2020, is $246.67. For a single person, goes up 10% for every dependent after that. And beginning on July 1, 2020, it's going to be $266.67 because of that middle of the year minimum wage increase. So everybody got this? So your rate cards and our cheat sheets that we use, thank you, Pat Talon, right? Make sure that you're scratching out those minimum rate numbers and putting in the correct minimum rates here, because I think it makes a difference, right? I think it's $220 right now, if I'm not mistaken, right? So it's a $26, like beginning January 1, it's a $26 a week difference, which is, I guess, better than poking out. So everybody should be aware that the minimum wage is going up. Okay, any questions, any concerns about that one? All right, good. All right, so everybody, I'm sure, has heard that On January 1, 2020, cannabis becomes legal, at least in some circumstances in Illinois. The cool kids back in 1979 used to call cannabis MJ or Mary Jane, right? So that's why I kind of just like that. In any event, this is Public Act 101-27, and it goes into effect on January 1, 2020. It provides that it's lawful for persons over the age of 21 to possess, use, and purchase some limited amounts of cannabis. This is a 300-page bill, so it's extremely difficult to read and to figure out. This is the synopsis. I took it right off of the Illinois General Assembly website. There's all kinds of exclusions and restrictions and exceptions and so forth, but generally speaking, if you're 21 years of age or older, you can possess and use a limited amount of cannabis. So how does that affect us as workers' compensation lawyers? Well, I think it affects us as workers' compensation lawyers because of the impact that it might have on Section 11, right? We talked this year about a number of cases that involve the intoxication or impairment presumption under Section 11, and this is it, right? If at the time of the accidental injuries there was 0.08, for the alcohol part, or if there is any evidence of impairment due to the unlawful or unauthorized use of cannabis as defined in the Cannabis Control Act. So, Section 11 deals with unlawful or unauthorized use of cannabis. So now that a limited amount of cannabis is legal, there's a question, at least in my mind, about what this restriction about unlawful or unauthorized use actually means when it comes to Section 11. By the way, I tried to read this new law, and I don't even know if the Cannabis Control Act even exists anymore. Representative Gasky, do you have any idea? I mean, it's really, it's a 400-page bill, so I don't even know if cannabis is even defined in the Cannabis Control Act anymore, or if that act even exists. But in any event, the use of cannabis is now legal, at least in some limited way, but the act continues to talk about the unlawful or unauthorized use of cannabis. So, yes,
I understand what unlawful use is, but what is unauthorized?
I guess if your mom says don't use, I don't know. So the question was, what does in this case unauthorized mean? I'm not sure, especially because before January 1, 2020, it was unlawful anyway. So, could it have been unlawful but authorized? Maybe medical marijuana, right? Maybe prior to January 21, maybe something like that, I guess. Yes, go ahead.
I think the operative phrase in this paragraph is evidence of impairment.
So our arbitrator Fruth brings up the phrase evidence of impairment, right? And we've talked a lot about that in this room, right? The difference between how the presumption arises when you're talking about alcohol, which is pretty clearly, if you blow 0.08 or higher, you're considered to be intoxicated by alcohol. There's some disagreement in the crowd here, I know, about whether a positive marijuana test is per se evidence of impairment that creates the presumption. There's a couple of cases that say not really. There's some opinion in this room that, of course, if you have a positive marijuana test, that's conclusive evidence of impairment, okay? But now, what if you admit to smoking marijuana 3 days earlier because it's now lawful in the state of Illinois? So there's a question about that evidence of impairment phrase.
I know of one arbitrator who believes that absent proof of impairment, the presumption does not arise.
So arbitrator Fruth brings up one of the arbitrator's feelings that absent evidence of impairment, the presumption does not arise. I happen to be in that same camp with that arbitrator. I think clearly the legislature was trying to make a distinction here between alcohol, how the alcohol presumption is created, simple positive test, presumption, right? For marijuana, they decided that there was something different, right? Because marijuana stays in your system for a longer period of time. You can test positive for marijuana even if you smoked it 3 weeks ago, right? So the legislature, I think, was trying to make a distinction there. So I think it does mean something. We've seen some commission decisions where even, I don't know if this is the right phrase, what might be considered very conservative commissioners have said, no, you need more than just a positive marijuana test. Is positive marijuana test evidence of impairment? Sure. Is it conclusive evidence of impairment? No way, right? So that's the question, right? How do you prove evidence of impairment? If you start with a positive marijuana test, right? But that's not where you end. And well, I think most of the careful responders in this room agree with that, right? You got to prove more than just a simple positive marijuana test if you hope to win the case, right? But now this throws even a positive test into question, right? Because you can use marijuana lawfully in Illinois. Yes, was there a question? The other one? Yes, sure.
The employer under this law still can maintain their zero tolerance policy for all drugs, including marijuana, THC, whatever. That may go to the unauthorized drug. There's going to be a lot of arguments about this going forward, I presume.
So George brings up the point that nothing in this new Cannabis Regulation Act changes the fact that an employer can have a zero tolerance policy regarding marijuana use, right? I think everybody would agree with that, right? Everybody would agree to that. But the question then becomes, how does that affect the workers' compensation case, right? So for example, you get into an interstate scaffolding thing, right? We would have been able to give you light duty, except that you had a positive marijuana test and we had to fire you. Therefore, we're not paying you TTE because you couldn't do the light duty because we fired you because you had a positive marijuana test. So yeah, I think you're right. I think we're going to be maybe revisiting some of these issues in the future. So the other question here is, right, there's this thing that says, in section 11, there's this phrase that says, if you refuse to take a test, that in and of itself creates the presumption, right? So as if a client is a marijuana smoker, right, I don't know that they ever want to refuse to take the test anymore, right? Because it's not illegal to smoke marijuana anymore, right? So it might have an impact on when people refuse to take the test, right? Okay, any other questions, comments, concerns about this one? All right, good. All right, so Public Act 101-550 becomes effective on January 1, 2020. We've spoken about this particular act here in this room a few months ago. This is the new law that says that it is no longer admissible to ask a person about their immigration status in a hearing. I think we decided that since this new provision was put into the Illinois Rules of Evidence, and the Illinois Rules of Evidence apply to workers' compensation cases, that it's no longer permissible, because the evidence is not admissible, to ask a person about their immigration status in the context of a workers' compensation hearing, or in the context of some workers' compensation proceedings, or something like that. What we talked about last time, which is something that we need to remind ourselves about, is that if a person tries to somehow prevent a person from obtaining benefits because they're threatening to ask them about their immigration status, that could be a Class C misdemeanor. So you know, be careful if that's in paragraph B here, be careful about how you're proceeding and, you know, whether you think the risk is worth the reward. In that case, there are certainly exceptions in this new law about when you can ask these kinds of questions, but as far as I can tell, you have to file some type of pre-hearing motion in order to do that, and it requires some kind of in-camera discussion with the judge about the immigration status issue, all right? So this brings up some evidentiary issues for us that I think we're going to have to deal with as we move into 2020. Any questions, concerns? Yes, Mark?
I don't think this impacts on vocational rehabilitation, because, you know, it's a federal crime to assist an undocumented individual in employment. So we have counselors doing job placement, and one way to read this statute is that they're not permitted to inquire as to the immigration status, and yet they're being hired to assist this person in finding work.
So Mark's question is how might this new law affect vocational rehabilitation, where vocational rehabilitation counselors want to ask an injured worker about their immigration status, because that will affect whether they can help that person find work or, you know, job placement or that kind of thing. So I'll throw this one open to answers. And anybody have some thoughts on this? Yes.
This says during the civil proceeding. That's not part of the trial. That's in order to do their job as part of what they're directed to do under the act. I think they can still ask the question.
So the answer from Representative Gasky is that, you know, if this is, it's only in the context of the hearing itself, right? So we've heard some legislative intent, right, there, but I'm only saying, I'm sorry, I probably shouldn't do that, but I think, but there's a contrary argument, right? I think there's a contrary argument, right? That if that vocational rehabilitation counselor is going to testify at the hearing, if there's a possibility that they're going to testify at the hearing, then I think that there's a valid objection to that question, right? And also, I think you got to take a really close look at this Section D, right? Section D talks about people attempting to deter, right, free testimony regarding this. So I can tell you that some of my clients have felt intimidated by that question from a vocational rehabilitation counselor, right? What is your immigration status? I'm sorry, why are you asking me that question, right? So look, some prosecutor might decide that it's, you know, worth going after somebody for a Class C misdemeanor if they can show that intent to deter, right? That kind of intimidation factor that is sometimes implicit in those kinds of questions. Right? Yes, Mark?
Well, one more point on that, and not directly related to the evidence rule, but we did have a situation where a respondent retained rehabilitation counselor asked by the client his immigration status. The client then asked the counselor, why are you asking me that question? And the counselor responded, because we have a Hispanic surname. Now, it seems to me more than a non-discriminatory reason to ask someone's immigration status. You can't just keep it a
So Mark brings up the point that, you know, you're going to have a valid reason to ask these questions, and furthermore, if you intend to ask it at a hearing, you're going to have to comply with the provisions of this act, right? Evidence otherwise inadmissible in this act is admissible if it is essential to prove an element, right? It's offered to prove an interest or bias of a witness. It's offered, it's not prejudicial, right? A person or his attorney voluntarily reveals the immigration status. You know, I'm not going to make that mistake anymore, right? So I think this, you know, when it first came up, people were like, what's the big deal? I think there's a lot in this few sentences here. So, you know, make sure you're not inadvertently making some kind of mistake. Yes, sir.
Rehabilitation agents have testified before me on this point that was brought up by my colleague here. They would testify that they follow the national T case, and all of the factors, including immigration status, deal with the variables under national T. So, depending on your view, they're getting around any prohibition. And I'm not saying there's bad intent on the rehab people, but that's their key guide is national T. So I throw that out there.
So, Arbitrator Andrews brings up the point that, you know, that vocational rehabilitation counselors use the national T case kind of as their guideline, and they tick off those, what is it, 11 or 12 factors in national T, right? And so it might be relevant in regard to that. But you may want to comply with paragraph C of this. If as a respondent lawyer, you want to bring that evidence into the hearing, you may want to try and comply with Section C here, which requires there to be some kind of pre-hearing determination about that with an in-camera inspection or what, you know, whatever it is of that issue. Okay? All right. When we talked about this new law going into effect, the other evidentiary issue we talked about was Rule 138, right? So everybody remember that discussion that we had, the Supreme Court Rule 138 that prohibits us as lawyers disclosing information about our clients in pleadings, right? So things like driver's license numbers, social security numbers, bank account numbers, right? So there's already been a horror story reported about a transcript going, on a review going to the Lake County Circuit Court, and the clerk in Lake County looking at that transcript of proceedings at the commission and saying this is not in compliance with Rule 138 because the petitioner's social security number appears in this transcript, and rejecting the filing of the transcript. Okay? So not only is it going to be an issue at the commission when you try your case, right? When you hand in your exhibits, they're all going to have to be in compliance with Rule 138, but it also has already been an issue in one of the circuit courts. So keep Rule 138 in mind. I need practical suggestions about how you can comply with Rule 138. Anybody want to take a crack at it? I mean, literally what I have done in a couple of occasions is take out a black marker and go through every page and just black out the social security number. In fact, I did it on a case that just went up on review. I sat down with my opponent and we went through every page of that record and struck out the objectionable Rule 138 information. Okay? So just keep it in mind because it'll save you some trouble down the line if you do it up front. All right? Any questions, issues about that one? Yes?
Does the commission allow us to take the transcript and generate the record and do a technical review to make sure that it's compliant?
So what Mike asks is, after the transcript's already been generated, can you do a second review to make sure that you're in compliance? I think you can as long as you agree with your opponent about that, right? If you and your opponent agree and you actually sit down at the same table with a black marker and how about this one? Yeah, okay, how about that one, right? And you do it, I think you can. I think the commission just wants to make sure that they're not taking in something that they shouldn't be taking and inadvertently creating an issue in the circuit court or the appellate. Can you imagine, briefing the case in the appellate court and standing up before Justice Hoffman and him saying, I don't have jurisdiction here because your transcript is not in compliance with Rule 138. You don't want to do that. So believe me when I tell you. All right. Anything else? Okay, good. All right, so what else is coming at us in 2020? Well, whether we like it or not, what's coming at us in 2020 is e-filing of the Workers' Compensation Commission. Okay, so you've all seen these cards that are being passed around up at the commission, basically warning our practitioners that beginning in early 2020, we're going to be adopting e-filing for the state of Illinois when it comes to workers' compensation cases. It's going to be a kind of a rollout procedure from what I understand, with registration for the law firms and lawyers beginning first, then working through how we deal with settlement contracts from an e-filing point of view, and then bringing everything else kind of online in the quarters after that in 2020. But in that first quarter of 2020, it's my understanding that there's going to at least be the registration process and the kind of rollout of how we're going to be dealing with the settlement contracts in terms of e-filing. We want every member to know, every WICLA member to know that WICLA is all over this issue on your behalf, okay? We have several members, including officers, who are part of the kind of work study group that the commission has put together to kind of work through these things. The WICLA board discusses e-filing at every single one of our monthly meetings. In fact, there was a motion for cloture the other day when I was filibustering about e-filing at the board of directors meeting, and it won unanimously, by the way. They told me to shut up. So, but what we want our members to understand is that WICLA is going to protect the lawyer's interest in this process. We're going to do our best to make sure that this is a system that works for everybody, including the lawyers, who are the primary, accessors of this kind of system. We're going to make sure that it works for everybody or die trying. So, early in 2020, WICLA, I'm sure we're going to have somebody from the commission here to explain to us how this is going to work, to answer all of our concerns about it, to answer questions. I've been banned from that meeting, so I will not be there, but Mark's going to answer my questions for me. So, in any event, what I want you to understand is WICLA is on the job for you guys when it comes to this issue, and we're going to make sure that this works for everybody. Okay? Any questions, any concerns? All right, good. All right. Couple of cases that I wanted to follow up with you about to make sure you know where we're at and to make sure that you understand that WICLA is following these cases, and we're going to report to you the results. The first one is this Hernandez case. If you remember, this is the case that was decided in the U.S. Bankruptcy Court and then in the 7th Circuit Federal Appeals Court. And I'm not a bankruptcy expert, but essentially what this case said was that an injured worker cannot discharge medical bills, workers' compensation medical bills, that are the result of a settlement, because that settlement is not excluded from the bankruptcy estate, right? Does that make any sense? So essentially, if an injured worker took $30,000, right, and part of that $30,000 disputed settlement was for disputed medical bills, and then the injured worker filed a bankruptcy case to get those medical bills discharged, what the district court judge, or the bankruptcy judge and the federal circuit decided was that you can't discharge those bills, right? If you've taken money in a disputed workers' compensation case for medical bills, right, you can't discharge the bills in bankruptcy because the workers' compensation money that you took for those bills is not, it becomes part of the bankruptcy estate. It's not exempt from the bankruptcy estate the way it is now, right? The way it was before this law, right? Right? Okay? So basically, you can't discharge medical bills for a workers' compensation case, even if you've taken a workers' compensation settlement and closed out the case on a disputed basis. The 7th Circuit said, look, we're not so sure about this. We don't really quite understand. And they engaged in a procedure which I didn't even have any idea existed. They said, Illinois Supreme Court, the 7th Circuit needs your help in interpreting what the Illinois law is in this regard. Because the medical provider's argument in this case was that when we adopted this fee schedule back in 2005, that changed the whole game, right? And that when the legislature adopted the fee schedule, what it really meant to do was make sure you couldn't discharge your bills in bankruptcy, right? So the Seventh Circuit said, Illinois Supreme Court, we need your help to give us kind of an advisory opinion about what changes were made or how this is going to affect bankruptcy law. And the Illinois Supreme Court took that petition from the Seventh Circuit. The case was fully briefed before the Illinois Supreme Court and was argued in the Illinois Supreme Court on November 20th, 2019. So it's been about a month or so since the case was argued in the Illinois Supreme Court. I expect that we're going to have a decision out of the Illinois Supreme Court here in early 2020, and so we'll make sure that you understand, you know, what that decision is. For those of you who have been following this, and I did a little bit, I listened to some of the arguments. If I were a betting man, I'd bet on the fact that you're going to be able to discharge your bills in bankruptcy because not only did the petitioner's lawyer bankruptcy lawyer do a really good job in the case, but there were also 2 or 3 amicus briefs filed in this case by, debtors' rights organizations and some other consumer advocacy groups and so forth. So my bet, and I lose a lot of bets, but my bet is that you're still going to be able to discharge your bills in bankruptcy. All right? Any questions, concerns, issues? Yes?
Dave, just real quick, did it specify in the initial judgment whether or not you had to list the bills as disputed? Or could you, let's say your contract terms say your entire settlement is for PPD only. Is that settlement still going to potentially require that you pay back bills if there are bills owed? Or would it only be if it said disputed medical as part of the language?
Yeah, so Carolina asked a question about whether, the bills were specified in the settlement. And I just don't know the answer to the question. I don't know. I don't know. And by the way, I'm not sure that it made any difference to the bankruptcy court, right? Because the bankruptcy court said, look, when the legislature changed how bills are paid in 2005, what they meant to say was that doctors always get paid, right? And that was their argument. And that's the argument that the Seventh Circuit said, well, yeah, we can kind of see that, but we're not the experts. The Illinois Supreme Court helped us out, right? So that's the issue was, doctors argued, and the medical providers in this case argued that because of the changes in the law in 2005, and I suppose even a little bit in 2011, that what the legislature was trying to say is that doctors always get paid in workers' compensation. Right? That's the law of the state of Illinois. And the Seventh Circuit said, maybe not. The Illinois Supreme Court please help us out. All right. Okay. So Gary Sagan is the TTE case that, we talked about a lot here. So you recall that this is the case where I panicked that, TTE was now again a thing in Illinois, when in fact what I think we decided was that what had happened in Sagan was actually a likely job offer by the respondent that the petitioner refused. So, the case didn't end with the commission decision that we talked about. It was reviewed to the circuit court. It's been fully briefed and argued in the circuit court before Judge Duffy, and the decision is due on January 9th. So stay tuned on Sagan, because we're going to have a decision about this one early in January. Any questions about Sagan? Any concerns, issues? Anything else about it? Okay, great. McAllister, Carolina, I'm glad you're here. You'll recall that Carolina did the presentation about McAllister, and Katie helped on that day. And it was a really, really excellent presentation by the both of them. So you'll recall what McAllister is about, right? McAllister is about the cook who is kneeling down to find the carrots that he thinks might have slipped underneath the shelf of the cooler, and as he's getting up, his knee pops, right? I'm sure it's much more complicated than that, but that's the simplistic version of it. So the appellate court said that manifest weight of the evidence, that was not an employment-related risk. The real concern, in my opinion, is this special concurrence in McAllister, where they said, yeah, the petitioner loses, okay, but when you're dealing with one of these kind of everyday activities or common activities such as kneeling, right, that those can never be analyzed under the employment risk analysis. Those always have to be analyzed under the neutral risk analysis because an everyday activity can never be an employment-related risk. Well, Carolina got the Supreme Court to accept a petition for leave to appeal on this case, and as you know, that's really difficult to do. If we get 1 or 2 Supreme Court cases taken up in 3 or 4 or 5 years, that's about as good as it gets for us, measly workers' compensation lawyers. But Carolina got the Supreme Court to take this case. It's been fully briefed as of yesterday, I think, or the day before. Brief, response, reply. The Illinois trial lawyers have filed an amicus brief in the case, and the case is going to be argued in the Supreme Court sometime in 2020, I suppose. What do you think, Caroline?
They set a date yesterday for January 15th.
Wow.
So 3.5 weeks.
So Caroline's got 3.5 weeks to get ready for you. So 3.5 weeks from now, the argument's going to take place. I think this is a big case for us, really. I know I tend to overvote things, but I think this is a big case because if this everyday activity exception kind of becomes the law, it's going to be real difficult for us to draw the line. What is not an everyday activity? If I can do it, does that mean it's an everyday activity? So stay tuned. This is coming up here. Great. I got through it all. Thanks everybody for a great fun.